Dear colleagues, let's continue the special joint meeting, and I kindly ask to invite candidate for the position of the judge of the Hague, Viktoriia Volodymyrivna Bazeliuk.
Добрий день.
Hello.
Розглядається питання щодо
We are considering the issue of compliance of the candidate for the position of the judge of the Hague, Viktoriia Volodymyrivna Bazeliuk, with provisions of the Part 4, Article 8 of the Law of Ukraine on the High Anti-Corruption Court. In this room, we have members of the PCA, Mr. Robert Hein-Broekhuizen, the chair of the PCA, Norman Haas, Mary Kay Butler remotely, John J. O'Sullivan, and Jessica Lott Thompson. And here we have also present members of the PCA, Михайло Богоніс, Ярослав Дух, Олег Колюш, Ігор Кушнир, Руслан Мельник, Роман Сабадаш, Руслан Сидорович, Сергій Чумак, Галина Шевчук. Viktoriia Volodymyrovna, do you understand the composition of this commission? Yes. And I'm telling you about your rights. You have a right to submit a motion of recusal to the commission members based on the provisions of the law. Submit motions and express explanations upon the agreement and the approval of the chair of the commission. Provide your explanations and provide documents, and if that's agreed, and challenge decisions. Also, I would like to inform you that information which has not been provided before the interview is not considered by the commission at the interview, but upon the significant circumstances, upon the motion of the candidate, or with the vote of at least 3 members of the HCJ or PCA, the decision could be made to attach the additional materials to the dossiers, or if we have at least 3 votes of the PCA. You understand? Yes, I understand. Do you have any motions or recusals? No, I do have no motions or recusals. And Yaroslav Duch is a rapporteur of your candidacy. Mr. Duch, over to you. Hello. Viktoriia Volodymyrivna. So we have Bazeliuk Viktoriia Volodymyrivna, who in 2008 graduated from the Yaroslav Mudry National Academy and received the specialist degree. She is also a postgraduate student and Department of Criminal Law and Yaroslav Mudry National Law Academy. And her topic of dissertation is criminal liability for illegal exploratory work on an archaeological heritage site. Madam Bazeliuk also has a PhD status, and she has an academic degree of an associate professor. Her working experience from October 2008 to September 2011, she was a postgraduate student at the Department of Criminal Law of the Yaroslav Mudry National Law Academy since October to for different years. She had different positions in the Yaroslav Mudry National Law Academy, and at this educational institution she held the position of secretary typist of the correspondence, and she was also an assistant lecturer for different years. According to information from the property declaration for 2024, Madam Bazeliuk works part-time as a research fellow at the Statistics Research Institute for the Study of Crime Problems of the National Academy of Legal Sciences of Ukraine. Since June 25, 2025, Madam Bazeliuk has received an attorney license to practice law. Madam Bazeliuk has submitted her application in September 25 to participate in the competition for the positions of judge of the Hague. And as of 16th September of 2025, the Commission decided to admit Madam Bazeliuk to participate in the competition and to pass a qualification assessment. As of 4th February 2026 decision, the Commission adopted the first results of the first stage of the competition, and upon this this result, the candidate has received 343.62 points, and she was admitted to the second stage of qualification assessment, specifically dossier review and interview. She's also participating in the competition for local court judge positions. She has passed successfully first exams, and now practical works which have been performed by candidates are under examination. That's all from my side. I give the floor to the chair. A small comment from my side. Yes, at the Stalsh's Research Institute, I stopped working since 1st January 2025 as a second employment. Thank you. Okay, the floor is given to the chair of the PCI, Mr. Robert Heinbroek-Heisek. Mr. Robert, over to you.
Thank you, Mr. Chair. Our rapporteur is Judge John O'Sullivan. John?
Thank you. Good morning, or is it afternoon now? Maybe afternoon. Yep, good afternoon. I'm going to call you Victoria if that's okay. I'd like to introduce you to the other members of the panel before we get started. Sitting next to me is Robert. Robert is an attorney in the Netherlands, and he's the chairperson of this committee. And next to him is Norman. Norman is an attorney in Estonia. And beside Norman is Jessica, who's a lawyer from Canada. And if you look up at the TV screen, you'll see a woman on the bottom there. That's Mary Butler. She's a prosecutor at the Department of Justice in the United States. And my name is John O'Sullivan. I'm a retired federal judge in the United States and a former prosecutor. So I want to ask you some questions today about your finances and some other matters. But before we get started, my understanding is that you're an associate professor at a law school, and you're also a practicing attorney. Can you tell me and tell us how that has prepared you to become a judge on the Hack Court?
Дякую за питання. Thank you for your question. And the first thing that I wanted to mention that I have been working for more than 15 years, specifically at the Faculty of the Criminal Law at the Yaroslav Mudry National University. So it means that I have experience of teaching criminal law, and I had also additional course on qualification of corruption offenses and corruption-related offenses. So as far as I understand, in the Hague, mainly we have criminal specialization. They have criminal specialization. Also, I studied the issues of sanctions. It was interesting for me, and I have even an academic article publication that I wrote. So together with another person, with a co-author, I studied the issue of sanctions, including sanctions in the format of confiscation, which is also the subject of jurisdiction of the Hague. And I studied this issue with practical employees. So I studied in practice how sanctions are applied. So not just in theory, but the practical side of this moment. And just recently, I also started my attorney's activities. I participated in court hearings, and it inspired me to participate, to submit an application for this competition. I realized that I like this work of a judge, and I have already a certain experience. That's why I decided to apply for the High Anti-Corruption Court and the local court. So I submitted applications for two competitions. It's because for the competition at local courts, judge positions, I submitted an application only for general specialization. And my choice was the following. So I wanted to have at least partially criminal specialization because I have already gained knowledge in the sphere of criminal law. And the High Anti-Corruption Court actually mainly deals with criminal specialization. And also, I realize that High Anti-Corruption Court, I can't say that you have less work there. No, judges are also quite low at this with work in comparison with local courts, but they have less cases. Those cases are just more difficult, more big, so comprehensive and bigger. And as an academic, as a scholar, I'm just used to work with less number of issues, but those issues are comprehensive and I need to dig into details. That's why I like the High Anti-Corruption Court. Thank you. That's all.
Thank you. you've been practicing law since sometime in 2025. How many cases have you had in that time span?
За цей час
For this time, I
приблизно 8
have
справ.
had
Це були
around
судові справи,
8 cases,
які є
both
досудове
court cases
розслідування.
and also pre-trial
Також,
investigation.
якщо брати
And
кримінальну спеціалізацію,
if we
я
take
взагалі
specifically
прекрасно
criminal
розумію, що
specialization, so it
зазвичай
happens that
представляла інтереси
mainly
навіть
I
потерпілих,
represented
не
interests
обвинувачених
even
кримінальних.
of victims, not defendants in criminal proceedings.
Одній
So,
справі,
in one of the
судове
cases
розслідування,
where it was a
мені
pre-trial
довелося
investigation stage,
звертатися
very
в
often I
регіон
needed
Київського
to
оскільки
reach out
правоохоронні
to an
органи
investigative
бажали
judge because
розслідувати
law enforcement
викрім,
authorities didn't
написала
want to fill in
клопотання
data into the unified
кваліфікацію,
register
але
of
мені не
court
дали
decisions.
застосувати
I
мову.
also,
Я її оскаржувала
there were some
судовому
other things.
закону.
I prepared the draft of the pre-qualification document, but they didn't provide me with a ruling, so I needed to submit a complaint. There were also sorting issues of divorce and so on. So up to 10 cases maybe, because I received the attorney's license back in 2025, specifically June 2025. And before that, I had also internship. So I had the attorney's exam in the end of 2024, then 6 months of internship, and only then I was granted with the right to practice law in June 2025. But specifically during that period of time, the exams and tests in the competition for the High Anti-Corruption Court and for local courts competition started. So it means that I didn't have time to take a lot of cases. And that's why it was around like up to 10 cases.
I'm going to ask you to be a little more precise in your answers because I have a lot of questions for you. Did you earn income from the practice of law in 2025?
Так,
Yes,
дохід.
I had some income. That income
невеликий, оскільки
was not big
більшість справ
because major part of cases is were my friends, acquaintances cases, and I had some.
розвивала свої навики. Це було
I was only on the stage of developing my skills. It was some kind of, like training myself. I didn't declare yet that income. I will declare it for sure because the attorney's declaration shall be submitted by 1st May. So it's still, I have some time before the deadline to submit the attorney's declaration.
So you haven't reported any income from as a lawyer to the in your response to questions in this matter, correct?
Так, ще не повідомила,
Yes, I have not informed yet because I didn't have such a legal duty. So my legal duty to declare it shall be done before the deadline. The deadline is 1st May 2026.
Now, in the declarations that you provided, you indicated that you have 20,000 US dollars or approximately 20,000 US dollars in savings. You indicated that amount at the end of 2024 as well as the end of 2025. I'd like to ask you some questions about that. I see from your responses that you had sold an apartment in the Poltava region in 2009, which you had a 1/3 ownership in. What did you do with your proceeds from that sale? And what were your proceeds?
Дякую за питання.
Thank you for your question regarding the selling of that apartment. It was joint shared ownership of me, my mother, and my brother. When the apartment was sold, I received 1/3 of funds, and it was around $4,500. immediately, I even didn't take this money from my mother. So my mother was keeping this money because at that moment I was only a postgraduate student of the second course. I lived in the dorm. So there was no sense to take this money where I live and store it there. I took this money from my mother somewhere back in 2015, approximately, when I started more actively accumulating money on purchase of my own apartment. So I accumulated this money in order to purchase my own apartment.
And 4,000 was the amount that you received or the total amount?
$4,000 це отримала я.
4,000.
Я дивилася
This is the sum that I received.
витяг з реєстру, який у
I
мене
looked at the extract from the registry that I have in the cabinet of judicial career. This sum is stated in hryvnia, but it was evaluated by the Bureau of Technical Inventarization, and I couldn't find the agreement of purchase and sale of the apartment, and it was evaluated for $14,000. I was not present during the purchase and sale. My mom acted in my name, and I lived in Kharkiv. I studied there and just visited my mom in Poltava from time to time. The notary that proved that has already died, but I couldn't find the copy of the purchase and sale agreement. And the extract from the registry is the Betty E. Evaluation Bureau of Technical Inventarization.
And how much hryvnias does that show that it was sold for?
Я не пам'ятаю
I don't
суми
remember
гривнях, оскільки розрахунок в доларі.
how much hryvnia, because it was in dollars, $14,000 approximately. And in that time, the exchange was 8 hryvnias to $1. But this is an assumption, and the BTI evaluation was about 37 to 38,000 hryvnias. But in fact, this amount was a bit higher, and my mom, she remembers that the real amount was stated in the agreement, and I did not calculate it in hryvnias, but it was according to the exchange rate at that time, $14,000.
Okay, you also said that part of these funds were used to purchase an apartment in Kharkiv that's owned by your mother since December 16, 2009. What portion of the proceeds from that sale were used for the purchase of your mother's apartment in Kharkiv?
Я знаю, що кошти від продажу цієї квартири,
I know that funds from sale of that apartment, a part of which belonged to my mother and a part of which belonged to my then minor brother, were used to buy that apartment. Why my brother's funds were used and mine were not? Because my brother was still a minor, and without the parental care bodies permission that apartment could not be sold as long as he was provided an accommodation. So she used the money to buy an apartment, and this purchase and sale of apartment in Kharkiv was done on a 2-year installment plan.
In your written explanations, you state that you started saving money in 2009. How much money approximately did you save a year from your salary to reach the $20,000 in savings you now have?
А у 2009 році я не мала як такого заробітку.
2009, I didn't have much income. I stated 2009 because the first sum of my savings appeared from the sale of the apartment. And I was not employed until 2019. Then I had an hourly rate, or I had 0.25 of the rate, and I couldn't really save much. Then I worked for some time, for a number of years, in following civil law agreements. I could save $100, $200 per month at one time. At the other time, I couldn't save anything. I had income from works under civil law agreements, and from my salary, I didn't have stable expenses. One month it was bigger, other months it was less. And additionally, all the income that I had under civil law agreements, I tried to save, and I also had 3 years of work part-time.
And that's how you were able to save the $20,000 over that time period?
Я пояснювала, що 20 тисяч
As I
доларів це
explained,
$4,500
$20,000 is for $4,500 that I got from the sale of the apartment, $2,000 in 2012. My grandmother gave me as a gift, and the rest was savings from my salary, and I didn't calculate that back then. But if you take a look at my declarations, then I may have saved that. I didn't have subsistence minimum. I had a little bigger income. I had some other jobs. 2022, I submitted those documents, a mini grant from a Polish foundation. That grant was about $2,300. And with time, they grew to be $3,000 because of the exchange rate changes.
I want to ask you about some vehicles you owned. You previously owned 2 cars, a 2008 Honda Santa Fe and a 2008 Honda Civic. During what periods were you the owner of these vehicles? And what was the value of each car when you acquired it?
Дякую за питання.
Thank you for this question. So I already submitted my explanations regarding these vehicles. Regarding Hyundai Santa Fe, in fact, I was an owner of this car only on paper. A friend of mine bought this car. For some reason, I don't remember why. It was in 2016. He couldn't be present at the transfer of property, and he asked me to become an owner for a few months and have it registered in my name. And since September 2016 to November 3rd, 2016, I was the owner of the car. Fewer than 2 months. And because I was the owner only on paper, I don't know the value of that car. And I didn't use Hyundai Santa Fe for even a day. Then Honda Civic 2008, I was the owner of the car since September 5th, 2018 to December 11, 2020, about 2 years. This car, I didn't invest in buying it.
Мій на той час
because my cohabitant back then, he was the owner of the car initially, but then the car was registered in his father's name. And once, when we were going to visit his relatives and we crossed the border, because there were changes in legislation of that country, we were not let to cross the border in that car. So we needed to come back to Kharkiv and to re-register the car. And you can even check the exits crossing of the border. September 4th, we wanted to cross the border. We returned to Kharkiv and re-registered the car in my name. Why? Because my cohabitant had a power of attorney in my name. He needed to re-register the car in someone else's name. No transfer of value happened there, but I did use the car. And in December 2020, that car was sold, and I just went to the notary office and gave back the power of attorney, and my cohabitant dealt with the rest of the operations. And I didn't get any funds from the sale because I was the owner only on paper.
In October of 2023, you were brought to administrative responsibility for failing to comply with a road sign. I believe at that time you were driving a 2014 Chevrolet Volt. Is that correct?
Так, правда.
Yes, correct.
And that car belonged to Yuri Milshin, your cohabitant? I'm sorry?
Так, правильно.
Yes, correct.
And in your 2024 property declaration, did you declare that you had the right to this automobile?
Ні, не зазначила.
No, I did not declare it. I didn't mean to conceal my ownership of the car, but I filled out the declaration for the first time, and I believe that I needed to declare about something that I really used, not the right of ownership and the real right of owning and using the car for 183 days was not a case. My situation, this car was available to me, and more than 30 days, whether I could use. So if I owned this car, and if I used the car more than 30 days, I needed to declare it. For the protocol, members of Commission Volkova and Omelian joined the session. You can continue.
On May 17, 2024, Yuri Milshin issued you a power of attorney for a 3-year period. Is that correct in regards to that car?
The question has been interpreted already. Yes, this is correct. I didn't indicate the fact of that power of attorney. I'm now realizing that having the right to ownership during
протягом
the
року,
power
мала
of
задекларувати.
attorney.
Тут, я розумію, допустилася помилки.
So
Але
it was a mistake that I
самовідчинності
did
в
not
мене
declare it,
особисто не було, оскільки ми
but I didn't
заключили
have
вірність.
the
Вона
power of
залишилася в
attorney
автомобілі,
myself.
і
We
ця
made it.
довіреність
It was
робилася
left
не з
in the
метою
car, and
користування
that power of attorney was
використання мною цього
issued
автомобіля на території України, оскільки я й без довіреності можу його
Mm.
використовувати. А про всяк випадок, виходячи
just in case I wanted to go abroad, not for me using it on the territory of Ukraine, because on the territory of Ukraine I could use it without it. And at the time of full-scale invasion, I was in Kharkiv, and without a car, it was really hard to locomote. So it was done just in case I could leave abroad with my child.
What time period did you live with Yuri, and when exactly did you stop living together?
The question has been interpreted already. So we lived together from 2013 to 2023.
And subsequent to 2023, do you continue to have a relationship with him?
Так, ми підтримуємо дружні і робочі
We are on good terms, on friendly terms, and sometimes we also cooperate because he is an attorney. We might have the same clients. We could even conclude agreements to be mutually exclusive in case one of us is unavailable.
And you continue to use his vehicle after you two were not living together?
Так, іноді користуюся.
Yes, I do use it at times.
When did you first start living with Yuri?
З 2013 року.
From 2013.
And are you aware that Yuri, he recently got his law license in August of 2024, and he used your address in Kharkiv as his address when applying for that license?
Так, адреса була зазначена
Yes.
моя.
He indicated my address where he used to live before, because it is a formality for attorneys. It is a correspondence address, and that address needed to be indicated for the Bar Association in Kharkiv, or to prove ownership right to an apartment, or to provide a lease of an apartment. And in Kharkiv, he doesn't own accommodation. He has accommodation in the suburban area. And for convenience, because I live at that address, he indicated my address. And he only uses it for correspondence. It's a formality.
So let's move backwards in time to September. I'm sorry, to June of 2017. At that time, you were traveling in a car with Yuri that was involved in a traffic accident, and you were charged with an offense for refusing to undergo an alcohol intoxication test. Is that correct?
Так, правильно.
Yes, correct.
And you actually went to trial in that case, correct?
Так.
Yes.
And at trial, the court found that you were not the driver of the car, but rather Yuri was the driver of the car. Correct?
Так.
And that
Yes,
Yuri
correct.
crashed the car into a building and then got out of the driver's side. And subsequently, you got out of the driver's side because you were unable to get out of the passenger door.
Так,
Yes.
And eventually, the court found that, in fact, you were not the driver of the vehicle and dismissed the case, correct?
так,
Yes.
And during that trial, you testified. Is that correct?
так,
Yes.
And the court found that the car was being driven by a man named Yuri, whom she, that would be you, knew slightly, and with whom she'd been traveling from the countryside. Is that correct?
так,
Yes.
And the court also found that you rode as a passenger with Yuri, whom you did not know well. Is that correct?
так.
Yes.
And in 2017, you had already been living with Yuri for some 4 years, correct?
Так.
Yes.
And at that time, Yuri had actually had prior charges of driving while intoxicated. Is that correct?
Правопорушення таке було,
The
але
offense was there, but
право керування транспортним
the right to drive a vehicle as of the moment of this traffic accident was not suspended, so he could still drive.
But he had been convicted in February of 2017, a few months before the accident. Is that right?
Ні, це не зовсім так.
No, that's not really
Можу
correct.
пояснити.
I can explain.
Okay.
У лютому
In
2017
February of 2017,
була винесена постанова
there was adopted a ruling of the local
про
court
позбавлення його права
on
транспортних засобів.
depriving
Тоді
him
на
of
суд
the
не
driving
з'явився.
license. He did not appear to the court hearing. I do not remember why, but he missed the
Потім
court
він
hearing.
оскаржив
Later on,
зазначену
he
постанову.
challenged
Оскільки
this
він
ruling,
оскаржив
and since he
судді
was
апеляційної
challenging it with a
інстанції,
court of
то вся
appellate
ця,
instance,
постанова
then
місцевого
this
суду,
ruling of the
вона
local
не
court
набрала
was
законної
not
сили, і
in
він,
effect
юридично
yet.
вважався,
And legally,
ще
he was
не
considered
позбавлений
as
права
not
керування
deprived
транспортним
of the driving
засобом.
license.
А постанова,
And
суду
the
апеляційної
ruling
інстанції
of the
набуває
Court of
вже
Appeal
після,
was
цієї
adopted
події.
after
Подія
this
дана
event.
відбулася,
This
24,
event
яке ви
took place.
говорите,
This
з ніч
traffic
21
accident
на 22
happened on the night from the 21st to
позбавлення
22nd
права
June,
керування
and
транспортним
he was
засобом
deprived of his driving license on the 23rd of June. This ruling of the Court of Appeal of Kharkiv region is available in the register, and you can find it there. I do not have it here. I did not provide it. I could only download it from the register, but there you would see only person 1, person 2, and it would not be clear that we are talking about Yuri there.
And when Yuri was arrested in January of 2017, did the police officer confiscate his driver's license?
Я не була присутня
I
під
was
час
not
тієї
present
події,
during that
але
event, but
у нас зазвичай
usually they either do not remove this driving license until the final decision of the court, or instead of the driving license, they give you a temporary license, a temporary ticket, so to say. So in any case, he was legally driving the vehicle. Either he still had his driving license or he had a temporary license. I was not asked what it was, so I did not ask Yuri. So I do not know whether he had this temporary license or his not seized driving license.
You never asked him if he was how he was authorized to drive?
Будучи юристом, я
While
розуміла,
being a
що
lawyer, and realized that in any case, after the preparation of the report on bringing the person to administrative responsibility under Article 130, the person at once is not deprived of the driving license, and the person has legal grounds to drive a vehicle. Frankly speaking, I do not know. I do not remember. That was in 2017, and I do not remember whether he had this temporary license or his driving license. I do not know. But in Ukraine, that's absolutely legal. And after such a report, the person still has the right to drive a vehicle until the decision of the court on depriving the person of the driving license comes into effect. And that decision came into effect after this traffic accident that we are talking about.
And was Yuri drunk when he got in that accident?
ні, під час даного ДТП
No, during this traffic accident, he was not drunk. Back then, we were returning from the rest. We were approximately 30 kilometers from Kharkiv. So that's why it was quite risky, at the very least, to drink while driving. Moreover, he had lessons learned from the previous situation. So he was not drink, but he was concerned because on the next day there was supposed to be the court hearing regarding the deprivation of his driving license. And when the police officers arrived, the conversation did not go well, so to say, and that ended how it ended. The report was prepared regarding me under Article 124 and 130, but he was not drunk. And I believe that this act is socially dangerous, driving while being in the state of intoxication. Neither I ever did that, nor I agreed to be a passenger of drivers who were in this state of intoxication, because I even have some sort of a psychological problem as to why I cannot do that, because my father died in a traffic accident. His brother also died in a traffic accident. These were completely two different traffic accidents with a difference of 10 years. And my father was a driver and his brother was even a passenger. So even being a passenger of a driver who is drunk, no, I've never done.
In your written explanations to us, you stated that if he did drink, it was not much. Is that correct?
В нас було тоді 3 водії.
Back then, we had 3 drivers. So we had a big company of people. We were by the river.
I just want you to answer the question I asked you, which was, if you stated in your written explanations that if he did drink, it was not much. Is that correct?
Я зазначила саме
I
так.
said that back then. I recalled that for drivers, we were buying non-alcohol beer. Drivers were drinking some alcohol-free beer. That was not much. I did not track how much, but I don't think that you can get more than 0.2 promille from alcohol-free beer. Maybe the drugger shows 0 or 0.1. But maybe he did have a bottle of an alcohol-free beer, but he was not in the intoxication condition. I meant not alcoholic beer. We were there for a long time, so of course he was drinking something, but he did not drink alcohol.
When the accident occurred, he actually fled, and eventually the police officers had to put him in handcuffs. He had no shirt on. Is that correct? And he was behaving inappropriately and aggressively.
Він не намагався втекти.
He did not try to flee. If he did try to flee, then since the moment of the traffic accident until the arrival of police officers, there was about 10 minutes for sure. So he could have fled before that. When the police officers came, I remember that they did not he did not inform his name and he did not provide documents. And indeed, special means like
Okay?
Після технічної перерви продовжуємо.
After technical break, let's continue our meeting. Please continue. So yes, these special means were applied to him, but not because he was aggressive. No. They offered to him to be taken to the police department for his identification of his identity, and he said that he would not go anywhere, and that's why they used these means. So there were no other events happening there. But for some reason, then they decided that it would be easier for them to prepare the report with respect to me rather than to take him to the department. So they released him and prepared the report regarding me.
And the police officer testified that you had a strong smell of alcohol in your breath. Your speech was slurred when you refused to take a sobriety test.
Перелічених працівниками поліції ознак
These
стану
signs of alcohol intoxication, no, I did not have them. They are just putting that all the signs to everyone based on the instruction of this inspection. The situation was the following. When the police officers asked me for my data, because I did not have documents with me because I was coming back from rest, but I provided my accurate data, not hiding anything. I thought that they wanted to note down my data and to use me as a witness or something like that. But later on, they started talking to Yuri. Back then, I was talking to my friends. So some friends with whom we had rest, and they also came there by then. Sometime later, the police officers came back and they gave to me documents, and they were telling me that I had to sign them. I, as a lawyer, of course, did not did not sign any documents without reading it. So at first, I thought that it would be a document like a report with respect to Yuri, and that I had to sign as a witness. But then I saw that it was report under Article 121 regarding the traffic accident prepared with respect to me. Then we had a misunderstanding with police officers, and then they offered me to undergo this drug test. I told them that I was a passenger, and the passenger is not morally or legally obliged to undergo this drug test, so I refused to do that. And then they prepared this report under Article 130 for refusal, but they could not prepare it without specifying some signs of alcohol intoxication. So of course they listed the signs of alcohol intoxication. But back then, I was calling at night my friend, Tony, and he also told me not to undergo this check with Drager and to state in the report that I was a passenger. Because if I completed this Drager check, then this way I would have confirmed that I was a driver, and then the report under Article 121 would be still in my name.
So you're saying that the police officer was lying when the police officer testified that you had a strong smell of alcohol in your breath and slurred speech? Just say a yes or no answer would be fine.
Так, ці ознаки
Yes,
перелічені.
These listed signs by officers were not accurate.
Okay, the last thing I want to ask you about is you've listed your registered place of residence since October of 2010 as a dormitory in Kharkiv. Why are you registered at this address?
За цією адресою я почала
I
проживати.
started living at that address while studying at the postgraduate studies of the National University. I lived there from 2009 and until I defended my dissertation. Then I moved from that dormitory, but the place of registration stayed there.
That was about 2012 that you left?
На початку 13-го
At the beginning of 2013, in 2012, in December, I had my defense, and in early 2013, I moved from there. So,
близько Нового року, там, з 12
after the new year,
виїхала з гуртожитку.
I moved from the dormitory, and then since then I have not lived there. I did not have a separate room that is registered in my name, and even I was submitting an application addressed to the vice rector of the university so that they would let me keep my place of registration there. So I have only the place of registration, but I have no right to use this dormitory, and I do not have a separate room in it.
And you haven't lived there since 2013, early 2013?
Ні, не проживала.
No, I have not lived there.
And in fact, the building is not inhabitable now, is that correct?
А наскільки мені відомо,
As far as I know, after the start of the full-scale invasion,
всі виїхали з того гуртожитку.
everyone moved from that dormitory, and it's conserved building. It's not destroyed, but it's just like a conserved building as far as I know. There is no heating, no water supply, and
Is that building subject to privatization?
Наскільки мені відомо,
as far as I know, no, it's not subject to privatization, especially given that I do not have a separate room there. So for sure, I'm not subjected to privatization rules.
And why did you submit an application to the vice rector to keep this as your place of registration after you moved out of the dormitory?
це питання мені не ставила, але я
That
можу
question was not asked, but I can explain.
Оскільки
Since
я це житло, в якому я проживаю, це житло належить
the apartment where I live, that is the ownership of my mother. My mother has my brother as well, with whom I will have to share this housing. So that's why I'm accumulating savings for my own housing. And before the full-scale invasion, I was considering different options of beneficial mortgage crediting for academic employees for 15-20 years. I thought that I could put my savings as the first installment, and to get that, it was a year and a half before the full-scale invasion. And the condition for the receipt of this beneficial credit for academic and pedagogical employees was that I had to be registered in the dormitory and to be in the line for receipt for improvement of housing conditions. I was registered in such a line. Of course, I understood that I would never get housing under this line, but I did that in order to be able to get a mortgage for an apartment and to pay for my own house. But the full-scale invasion started, and I did not have time to do that.
And what year did you make that application to the vice rector?
Я не пам'ятаю, можливо,
I
це
do not recall that. Maybe it was
20-й.
2020, approximately.
До цього в мене просто
Before that, I just had my address of registration there. No one asked me why I had it, and I was not withdrawing this registration either.
Okay, thank you. I have no further questions at this time.
Thank you, John. Mary, questions? Back to you, Mr. Chair.
Дякую. Пане
Thank you.
Ярославе, вам слово.
Mr. Yaroslav, the floor is yours.
Пані Вікторія, продовжуючи
Madam Victoria, continuing questions just to finish the discussion of this Maltas apartment where you live. Please remind us how you were looking for this apartment, who was looking for it, and how.
Вибачте. підшукувала в більшій мірі я
So
цю
when
квартиру.
we looked for this apartment, it was mainly done by me because I lived in the city of Kharkiv at that moment. My mom didn't have money to purchase this second-handed apartment or property. So I looked for newly built apartments with a possible installment opportunity to pay later. So this apartment was purchased at the moment when construction was not yet finished. Elevators didn't work, there was no heating supplies there. So it was an opportunity to purchase apartments from a developer with certain internal construction works done, such as availability of heating, gas supply, and so on, and some works done on the walls. But we purchased that apartment when it was in a condition absolutely not suitable for living. So there were no internal walls, and all communications, all utility connections were delivered only to the entry of the apartment. So inside the apartment, the pipes, cables, and so on should have been done. So in the end of 2014, it was the moment when I relocated to that apartment. So regarding the to conclude sale and purchase agreement, did your mom come to Kharkiv to conclude this and review the apartment? Yes, in order to look at the apartment, yes. But at the moment of conclusion of the sale and purchase agreement, she was not present because she issued a power of attorney on my name, the same as I did issuing power of attorney on the name of my mother to sell an apartment in the Poltava region, because those agreements were concluded during 2 days in a row. So I think it was 15 February when my mom sold an apartment in the Poltava region, and next day I purchased on her name an apartment in Kharkiv. So the key doubt here regarding the following: your mom doesn't have enough official income to purchase any property of such value. That's the first thing. And secondly, objective, your situation shows to us that you were interested in purchasing apartment and property in Kharkiv rather than your mom. So please tell me who was actual beneficial owner from this agreement, and if you used your mom's funds to purchase it, how did she earn it? So what's the source of income for her? The initiator to purchase an apartment was my mom, because she realized that I'm going to stay in Kharkiv. It was a period when I graduated from the university studies, but was enrolled already at the postgraduate studies. So during my study at the university, there was no such opportunity, no such sources of funds to purchase it by me. And at that moment, the issue of my employment was still on the table. It was unclear where I'm going to stay and work. In 2008, I started postgraduate work. So in 2009, it was already clear that I'm going to stay in Kharkiv. And my mom decided in such a way that the apartment in the Poltava region, she didn't need it because she had a house. So that apartment in the Poltava region was not needed for anyone, for her, either for me. So she suggested to sell that apartment and invest into apartment in Kharkiv. But it's better to have it with installment payments because there was not enough funds to pay at full from the very beginning for apartment Kharkiv. My mom was all the time officially employed. Her income wasn't that high, but major part of funds for this apartment in Kharkiv originated from selling of the apartment in the Poltava region. And there were also some savings of my mom, which originated from her individual gardening. She lives in a village where just ordinary grassroots neighbors like her and she also. So they just had some vegetables, fruits, and so on. And in such a way, they managed to save some money. The difference in prices between apartment in Poltava region and in Kharkiv region was not that high, because apartment in the Kharkiv region was without anything at all. Sorry, I understand, but I want to clarify. Your mom received 113,000 hryvnia from 1998 to 2009, and her cohabitant registered only 5,000 hryvnia during all that period of time. So So she lives in the village, am I right? Yes. Where did she sell her gardening and fruit products? Everywhere. So there, in the same place, in Kotelva village or in Poltava. Maybe she visited Poltava for this purpose, but not very often. That's quite, so what's the difference in kilometers from Kotelva to Poltava? 50 kilometers. It's highly unlikely that she will do it. Yeah, sometime during when I was still at school, when they were younger, they indeed traveled to Poltava to sell their products, but not now. Do you have any confirming documents, underlying documents that she transferred some money to you and that you agreed on such purchase of an apartment? My mom issued a power of attorney to purchase an apartment on her name, but it was 4 days before the purchase of an apartment. But it doesn't confirm that your mom knew the technical details of the apartment, that you somehow agreed on those details. It just gives us a sign about giving you some powers as a person who is going to live further in the apartment, to conclude an agreement to serve your own interests. Sorry, I didn't get your question. So my mom visited Kharkiv. She saw the apartment. There was actually nothing to see. So it was just a building, multi-apartment building, a floor. So she saw that the apartment was yet on the construction stage, nothing to check, nothing else. So, she saw the location, where it's located, and she authorized me to purchase the apartment on her name. But when I failed to take a loan, I started thinking. So at the very beginning of the full-scale invasion, I didn't think about anything at all. But now I have been thinking that if I keep staying in Kharkiv, so maybe I will need to divide this apartment in terms of ownership in between of me and my brother. So maybe I shall repay his part to him and become full owner of this apartment. So. Of course. So my mom bought it for me, but as there are two of us, she cannot give it as a gift only to me. Okay, thank you. The next question. There is a ruling of the court which says that the guardianship service or authority of the Kotelyev-Poltava Regional Administration submitted a lawsuit to serve interests of a minor child to 3 persons regarding the sale and purchase agreement to consider it cancelled or not binding, that this agreement is not effective. Can you explain the details? Frankly speaking, I don't know anything about it. That's the first time ever I heard about it. So at the moment of selling the apartment, my brother was a minor one. So it was a necessity not just to register him at another apartment at the property, and there was only 1 month granted by the law to register her minor son at the property. So that's why maybe she violated the deadline, and I don't know the details. No one summoned me to appear in front of the court, but I couldn't assume. So it was no intention to not register him, but just because of the technical reasons, she failed to register him at another property location before the deadline. So there was no such court litigation. My mom didn't inform me of it. I didn't look at the court register. I only know that there was even if it happened, there was no continuation of such court litigation, because my brother has received part of the house where my mom resides right now as official registration place. Another question: were you a political party member? No. So you participated several times in different elections, and you were a representative of the election precinct. Please tell more about this role. Did you present any political forces or parties? Yes, indeed, it was on many occasions. It was usually during my studies, when I was a student and a postgraduate student once. It was an additional source of earning for a student, and that's why I participated in such activities. So it was only twice, yeah? Well, please clarify, which political party did you present at that moment? So first of all, Nasha Ukraina, it was Our Ukraine political force, when it was Orange Revolution, and I was engaged in all three stages. Not all such activities and of cooperation were documented. I know that back in 2012, I worked as a lawyer at the headquarters of the party. The party name was Udar. So I didn't have any internal political beliefs. No, it was just my work. I was not a fan of any political party at all. It was just work for me. Why I'm asking? Because according to the tax service information regarding your income, there is information available regarding your work in election precincts and election commissions, but there is no income received by you as a representative and member of political force. Was it free of charge? No, it was not free of charge. Okay. The next question is related to the land plot acquired by you in Kotelva village. Did you plan to relocate to Kotelva village, or what was the need to register the land plot on your name? No, I didn't plan to relocate. That land plot was an adjacent land plot to house of my grandmother. So I spent a major part of my childhood at my grandmother's place. At that moment, at that land plot, there was an abandoned house. When I was, at primary school, no one had lived there. It was just an abandoned house, and I spent childhood also there. And my grandmother wanted to buy that land plot. She tried to find an owner of that land plot, but the owner of that land plot actually has left Ukraine for abroad, and my grandmother failed to find her. So for 30 years, the land plot and house was abandoned, and then it was moved to the community's ownership, both the land plot and the house. So 15 arcs, so some parts of the land plot, I decided to take under my ownership, and that land plot was a part of the yard in front of the house. So because my grandmother wanted to do it so much, but she failed to do it. So afterwards, after the death of my grandmother, in the house of grandmother, my cousin lives. But this land plot, which was privatized by me, right now is used by my stepfather. He is a farmer, and he keeps some technical equipment there. There are no capital structures built there. Regarding this land plot, why I'm asking? Because it's caused by two reasons. The first reason, that your mother had received a few land plots under her ownership before it, both for gardening purposes, agricultural purposes, construction purposes. And so as far as I understand, so your relatives and close persons had already used the right for free of charge acquisition of property before you. So as far as I understand, you didn't drive to Kotelva, you issued power of attorney to register the power of that land plot. So your interest was not that high as you have just described it. So what was your key motive to get that land plot? In order to get it just free of charge, or what was the reason for you? No, my mom was an initiator of this acquisition. So she told me that there is an opportunity that the neighbor privatized part of that land plot, so the gardening part, and there is another part under which the house is located and the yard is located. It's still not privatized. Nothing is there. The house is almost fully destroyed, so we can privatize it. And I agreed to privatize it because my grandmother wanted to do it before, a long time ago, and that's why I decided that it's a good thing to do. So I don't actually dig into details of land issues of my close persons. They know how all these issues. My stepfather is a farmer. He has some land plots under his property, and He has some land plots under different methods. I don't know whether my close persons received any free of charge land plots. Was there that structure installed on the moment during the moment of privatization? But no. But according to data and to the maps, we can see the temporal structure, this hangar for preserving technical equipment, was there still starting 2017. I don't remember. I remember that as of the moment of privatization, so there was an old, very old house in a very bad, dilated stage and condition. Yeah, I remember there were some structures, some, in very bad condition. Yeah, we were dismantling them. Maybe that's actually that was it. And regarding declaring, how can you explain that in your family ties declaration, which was submitted by you for 2020-2024 years, you mentioned a person with whom you cohabitated for a certain period of time, but in your candidate's declaration for 2024, you failed to declare this person because I had lived with him till 2023. And it means that when I submitted declaration for 2020-2024 years, yes, I needed to mention it, but when I submitted declaration only for 1 year, 2024, I didn't need to declare it. Maybe I got it wrong, but I thought that I still should not declare it. Chevrolet vehicle, when it appeared? At the end of 2020, beginning of 2021, that was a vehicle bought from the US auction. I don't remember when it was specifically registered, but it arrived to Ukraine in December 2020. Why the power of attorney was issued on your name in 2 years after the start of the full-scale invasion, rather than it was at the moment when it was a real need to have an opportunity to quickly leave territories which could become hostilities areas or under shelling. So first of all, we were on the trips together with him, that's first thing. And then when we separated with him and we realized that the situation could be different, and I was thinking about an opportunity to go abroad. It was not my thought, it was my mom's thoughts and ideas, but I decided that I will stay in Ukraine. I will not go anywhere, but just in case Yuri is not eligible to go out of Ukraine, to leave it, so to say. And that's why the power of attorney was issued on my name for giving me an opportunity to go abroad. Not and I don't need the power of attorney to use it in Ukraine. And regarding your trips to the Russian Federation from 2018 to 2020, so after 2014, you systematically visited the Russian Federation. What was the need for it? So the issue is that the grandparents of Yuri were citizens of the Russian Federation. His parents were born in the Belgrade region, but after school, they relocated to Kharkiv, and major part of their time and their life they spent in Kharkiv. Yuri was born in Kharkiv, and he's Ukrainian national. But it happened that his grandmother was bedridden, became very sick, and that's why his mother needed to retire in advance earlier when the age of pension, and that's why that was the reason. So she was living in the Belgorod region, very specifically. It was the Belgorod region, Soltatskaya village, Rogidnyansky district. All trips were specifically to that place, to that venue. They were connected to family issues. First, we went there to meet his parents, then to help them with something, then to the funeral of the grandfathers, and to help with something. So there were several visits specifically to that village, Soldatska. But I think that for 1 year there were 7 or 8 trips. Do you think that it was indeed such a need? And do you think that it's appropriate to have a systematic visiting of the enemy's territories as you didn't have direct family connection with them?
Я не вважаю,
I
що
don't think
це було
that
гарне моє рішення,
it
але
was quite a
справа в
good
тому, що
decision from my
законодавчих заборон
side,
не було,
but there were
краще
no
була б
such
справді з'явилась,
legislative
змогла б хоча б
bans.
розумно
But of
пояснити
course, it
своїм
would
близьким особам
be
на той час, чому я
better
не можу
for
поїхати,
legislation bans
допомогти
to
і так
exist,
далі.
because I could have used it as an explanation for my close persons why I can't go and what could be my motives not to go there. I didn't participate in any competitions at that moment. It doesn't mean that I have some good attitude regarding the Russian Federation. No, no, no. But I failed to explain in a reasonable manner to my close persons why I can't go there. But, you know, the criteria of decisiveness and responsibility in your actions, are you sure that as a judge you will be able to be decisive and responsible in your actions and deny and refuse to fulfill any request from your colleagues or friends if it violates law? Or if it's not clearly banned by the law. No, no, of course not. I just didn't know that I would need to justify my trips later. I didn't do anything illegal. And at that moment, I didn't have any intentions to participate in any competitions. Tell me, please, the price of alienation of Honda vehicle.
Я була присутня виключно
I was present exclusively at the notary office in order to give a power of attorney in your honor. So it means that we didn't re-register that property.
Ви видали доручення посередникам.
Так, я навіть не була присутня так при
So you provided the intermediaries with the power of attorney, and I was not present. It was only about giving them the power of attorney, and I was the owner only legally speaking. And 49,000 hryvnias, according to the tax service, is the sum value that you got from the sale of that car. Well, is this an objective value? 49,000 hryvnias, as I explained. It was an agreed value that we stated just for me to be able to live abroad. Actually, I didn't get this amount, and I saw it when I ran for the competition. And as I started checking my income, and I noticed that amount. And the last question, in your questionnaire, in the section, whether any court decisions have been issued regarding you, could you enumerate them? What I meant there was probably not court decisions, but orders under Article 130. So are you not familiar with a separate institute, a separate notion of decisions? Well, I just indicated, just in case, indicated those decisions, just in case, so that I'm not suspected to conceal information. No more questions. I've got a question regarding your scientific publications. In your publication in 2021, you state it is
новостворених антикорупційних органів.
You name the Supreme Court among the newly established anti-corruption bodies. Is the status of the Supreme Court known to you? According to the law on corruption prevention, anti-corruption bodies are listed there. The police bodies, NABU, Anti-Corruption Agency, Prosecutor's Office, and you also mentioned the Supreme Court there. I cannot explain that. It's hard to explain. So whenever someone does it, I ask, is it correct? No, it is incorrect. Then you express a sort of other scientists in that article, the previous ex-head of chair the Supreme Court, and you say that Hague is not a specialized court because it doesn't have a specialized or separate procedural
Скажіть, будь ласка,
um,
а яким чином можливо
law.
окремий процесуальний закон взагалі для
How is special procedural law, so this is
На момент
terminology in
написання
Ukrainian,
цієї
is possible?
публікації я не
At the moment of publishing that
детально
article,
вивчала
I did not study the Hague court activities in much detail, and it was an early stage in the Hague court activities, and I did not really
окремий процесуальний
understand
закон
it well.
для
Is a
будь-якого
separate procedural
Я вважаю, що в цьому немає
legal act possible for any given body?
Вищий антикорупційний
Well,
суд розглядає кримінальну
because the
спеціалізацію.
Hague
Він має
court
керуватися
has a
кримінальним
particular
процесуальним
jurisdiction,
кодексом, так,
is supposed
де
to be governed by the
відповідними активами
criminal
для цього
code.
є у нас
For unjustified
цивільний
assets, we
процесуальний
have
кодекс,
civil
тобто потребу я не
procedural
вбачаю
code,
в такому
so there
новому
is no need
процесуальному.
to have a new procedural legal act. Okay, got it? You also did an analysis of sanction application. My question is, in your opinion, when considering such our so-called sanction, is Hague supposed to check the grounds to apply sanctions by the
Вважаю, що ні.
Security and Defense Council?
Вважаю,
I
що
think that no. I think the Hague Court is governed by the submitted documents, and other things should be subjected to other corresponding bodies like Security and Defense Council. Appealing a Security and Defense Council decision can be a reason to stop proceedings in sanction cases. No. Any other questions, colleagues? Ruslan. Thank you for this possibility to ask an additional question. Commission Member Melnik. Just a quick question. So when answering the question of the Commission Member Duch, your trips to the Russian Federation can be explained by the fact that you couldn't find a reasonable ground to refuse such trips. You couldn't explain it well to your de facto husband in his trips to visit his relatives, and you remained in such relationship with him until 2023, as you said, and your trips to the Russian Federation stopped in 2020. What does it mean? Did you eventually find arguments to refrain from such trips? Or were there any other circumstances? These were other circumstances that helped me to stop those trips to the Russian Federation. It was the pandemic and the ban. And because I didn't have relatives in the Russian Federation, I wouldn't have been led there. So I didn't have to look for any argument. So it was a ban to enter the Russian Federation. Thank you. And one more question that I forgot from your questionnaire. You indicated that you provided scientific and legal conclusions following the attorney's request. Are such conclusions proof in a criminal proceeding? No, they're not proofs, and it is up to the court to whether use them or not. It is not their obligation. The court might benefit from them. In which cases can the court use them? So you are the Hague Court already, and the defense gives you a motion on adding a scientific and legal conclusion on the application of the law.
Дуже часто такі подаються клопотання щодо незаконності дій апеляційного суду щодо надання
the unlawfulness of the decision of the appellate court about NSRD.
Суд
А.
повинен був здійснювати розподіл,
And then the conclusion says
в апеляційному суді і
that
так далі. Ваші дії. Ви долучите
processes should have been automatized, and that is not done in the appellate chamber. Would you consider this and would you use it?
Це право суду, а не обов'язок. Тобто
This
суд
is a
може
court's
і
right
залучити
rather than
це, і
obligation.
не
The court
залучати.
can include it to their consideration or refrain from it. So if you include it to your consideration, then you need to evaluate it somehow. Can it be a proof?
Дорівнюється до висновку спеціаліста, скажімо.
So that equals to a specialist conclusion. Yes, it could be a proof, but can it be a proof in a criminal case?
Чи може бути використаний він як доказ?
Can it be a proof in a criminal case?
Ну, так, це може бути
Well,
використаний як
it
доказ.
can be a proof. Thank you. If there are no other questions, dear colleagues, then you have 1 minute to state things that you haven't stated before
Не встигли.
that you would like to. Thank you.
Сподіваюся, що я все зазначила.
I hope that I have stated everything and I have provided comprehensive answers to all the questions. I would only like to thank the PCIe members, HQCJ members, for the time allocated to me for studying my dossier for this interview. Thank you. Thank you too for your participation in this interview. The interview is over. Thank you. Stay well. And